Rosenberg on the Homesteaders Store hotline. Homesteaders Store, good people with the right stuff, Kubota, LS Tractor, and Cub Cadet. Before we get into you intervening, Will intervening in the school choice lawsuit, how is it that a bar, a brewery, a tap room can sue school choice out of existence, Rick? How is that possible? Can I, intervene as well along with you? Because I'm just a random person too.
So, the guy that runs this brewery has a PAC, and he announced that the PAC would raise money, and they would hire lawyers, and they would find people to challenge the school choice program. So he's got, 4 or 5 people who are live around the state. A couple of them have kids in school. One of them has grandparents in school. And they have brought this lawsuit. And I don't mean to be cruel, but I can only say that I don't think he raised much money because the filing is, let's just say it's a target-rich environment.
It's remedial. That's what you're trying to say, isn't it?
You draw your own conclusions.
Okay. So Rick, would you say it sounded like a non-lawyer perhaps wrote it?
No. I mean, I wouldn't say that. I mean, look, the problem with this is that the arguments that are made just don't work.
What's the claim? Yeah, what's the claim?
Well, there are a couple of claims. One claim is that school choice doesn't serve a public purpose. Now, this was considered by the Wisconsin Supreme Court back in the 90s. The program was smaller then, but it did conclude that, of course, school choice serves a public purpose. The public purpose is educating children. And I don't think that that's changed in the last 30 years. In fact, if anything, the public purpose doctrine has gotten weaker before the court. And, there are all sorts of social services that are provided and paid for by the government that are not provided by government employees. And that's really all we have here. They make the argument that this violates the uniformity clause for very convoluted reasons that I'm not going to try to bore your listeners with, but suffice it to say that if they're right about this, then the whole school finance system, including the provision of equalization aid, that is the idea that poor school districts would get more money for the state, so and then other districts, rich districts, would have to rely more on their tax revenue. All of that becomes unconstitutional, and so steps that were taken to equalize, I'm going to say Milwaukee with Mequon or Madison with pick a expensive suburb around Madison.
Shorewood, something like that. Yeah.
Right. Something like that. That this is all no good because it violates this uniformity provision. I just don't think these arguments work. And it really all amounts to the fact that these folks don't like school choice. They think it's a bad idea. I think it's a bad public policy and we shouldn't have it.
So it doesn't do it. They're not claiming harm, though. They're claiming that it doesn't serve a public purpose, which, as you explained, I mean, okay, maybe you could. I could probably make the argument that education, when you have 37% proficiency, isn't actually serving a public purpose, but I don't think that would fly in court. So, or a uniformity clause claim, are they claiming anybody's harmed? Who's harmed?
Well, they say that the school districts are harmed. The way the program works, if you've got a kid who goes to a choice school, your state aid is reduced by the voucher amount. That's how it gets paid for. And the problem with that argument, of course, is that there are all sorts of things that cause that to happen in Wisconsin school financing system, and beyond that. Beyond that, they have fewer kids to educate.
Yes. So one, you don't have to educate the kid. Oh, that lays bare the lie that all of the money we're spending on schools actually goes to educating kids. But two, open enrollment does the same thing. Does he want to obliterate open enrollment along with school choice?
Right. I mean, that I didn't mention that one, but that's another thing that gets called into question under this theory. So, I don't want to. I just think it wasn't poorly. It was poorly thought through. It really doesn't have a lot of legal merit, I can't predict what will happen, but it's just not a very strong case.
All right. It doesn't have a lot of legal merit, but in a highly politicized environment, would something that even is goofy on its face, in a highly charged political environment like we have right now, that kind of worries me. What do you think about that?
Well, you always worry about that. You obviously, school choice is something that a lot of people have opposed for a long time. But that's not an issue for courts. If these guys think that school choice is a bad idea and we shouldn't have it anymore, then they need to go to the legislature. If they don't like the composition of the legislature, then they need to change it by running people for public office. And no, it is not the case that gerrymandering would prohibit them from doing it. They could do it. They wouldn't win, I don't think, because the thing about school choice is that it serves a large number of families, about 2/3 of which are non-white families. They're all low and middle income, and they like the program. They believe that the program serves their children well, and they are not going to take kindly to a lawsuit ginned up by some wealthy guy from Minocqua who wants to take it away from him.
Some wealthy white guy from Minocqua who wants to take it away from him on behalf of the demands of the teachers union, run by a bunch of white people. So this is, I just think this is just absurd. You have to intervene in this, but here we are. So it's been filed, right? The case is filed.
Right. But what they've done is they've asked the court to take this as an original action. And you may remember this was particularly something that happened a lot during COVID, where there were questions, and they were just legal questions. There weren't any facts. You didn't have to have a trial. You didn't have to have witnesses. And there were a lot of original actions that were granted by the court. And some of the justices, I think, were concerned about that. They didn't think that they thought that we were having too many original actions. This is a pretty poor case for an original action because it's very complicated. And although they say that they're not, there are many disputed facts involved about the impact of the program. And so it would be, I think, be pretty unusual for the court to take this as an original action. This is not the type of case that they typically dispose of.
A rational court, yes, if they were rational people. The impact, I mean, we've seen massive increases in spending for traditional brick and mortar K-12 public schools. I'm not sure you can even argue impact at this point. Would it go to the Supreme Court of the United States if, in fact, things went sideways and, people aren't rational on the court? Would a disfavorable opinion, could you potentially take that to the United States Supreme Court?
Well, it always depends what happens, but I think in this case, the arguments that they're making are arguments that are rooted in state law. The uniformity clause is a provision in the Wisconsin Constitution. The public purpose doctrine is a creature of Wisconsin law. They've got some other arguments that are also based in Wisconsin law. So typically the United States Supreme Court would not review those.
They're hoping to get lucky. They want to pull a rabbit out of a hat. I'm very, very pleased that the lawyers at Wisconsin Institute for Law and Liberty are asking to intervene. When do you know if you are granted that? Rick?
Well, I mean, the first thing we have to find out is if the court is going to. The court generally will do one of two things when it's asked to take an original action. Sometimes it will just deny it. It looks at the papers and doesn't want to do it, and they don't ask anybody to respond to it. They just say no. That happens a lot. Or if they think that they might take it, then they ask for a response, and at that point we would file a motion to intervene, and we would respond and say that we don't think that that this case is appropriate for an original action.
I do appreciate the time on the program, Rick. Things are definitely not boring in Wisconsin, and you're not running out of work. Great to have you on the show.
That's true.
Yes.
Take care.
From the Wisconsin Institute for Law and Liberty, Rick Essenberg.